And thank you, Patrick, and thank you, Alan, for taking the time to join us for this discussion. This is a topic that every once in a while it comes across our desk, but it's quite something unique in Brazil. It's not regulated, so it's really a topic that raised a lot of curiosity down here in Brazil. And we thought maybe the best way to engage the discussion would be to having people from other jurisdictions that have some knowledge of the topic and are more used to having those types of discussions. So we thank you very, very much for joining us and sharing with us your experience and your knowledge on this topic. It's really appreciated.
Absolutely, Jose. Thank you. Thank you very much for inviting us to speak today. Well, thank you very much. For those on the line, thanks very much for joining us. My name is Patrick Ashby, and I am counsel in the litigation group at Linklaters, New York. And I'm going to present today on the U.S. perspective and then hand over to Alan, who's going to give a little bit of a flavor for the European perspective. And before we jump in, just a little bit about myself and my background. I have a fairly broad practice, quite a bit of complex litigation experience, in particular in the antitrust world with respect to securities litigation and with respect to M&A litigation. And I also have a pretty significant governmental investigations practice, contentious regulatory practice, whether it's False Claims Act, Foreign Corrupt Practices Act, AG investigations, financial services investigations, and the like. And so across that practice, I've had occasion to enter into joint defense agreements in a kind of a variety of contexts. And hopefully I'll be able to share some of that today in a way that's useful and of value to you. So why don't we turn to the next slide, which has our agenda. Just at a high level, it's going to be a bit of a whistle-stop tour. We'll start with some discussion around U.S. privilege law, which really joint defense agreements from a U.S. perspective are firmly rooted in U.S. privilege law, and in particular, the attorney-client privilege, which we'll discuss. But then we'll turn to joint defense agreements themselves and common interest privileges, try to talk through some practical points around them. If at any point there are questions, by all means, let me know. I know Alan and I have planned to save a good amount of time at the end for questions as well, but I'm certainly happy to receive them at any point, so just let me know. With that, why don't we dive into it and we can turn to the next slide. So as I previewed at the start, I think to discuss joint defense agreements from a U.S. perspective, you really need to start with the concept of privilege. And in the United States, there are two primary key forms of privilege, and most other forms of privilege in the United States are in some way rooted in these. So the first one on the left-hand side of the screen is the attorney-client privilege. And the elements have been set out on the slide, but it requires a communication that's made in confidence between privileged persons, which can be an attorney-client relationship. And the communication needs to be for the purpose of seeking, obtaining, or providing legal advice. The attorney-client privilege is by far the oldest form of privilege in the United States. And it's one of the most absolute if you protect it. As long as you don't waive it, it is a very, very strong shield in the United States from materials being produced in discovery, from the production of materials to government regulators, from materials being used at trial, so on and so forth. It's a rather firm privilege as long as you don't stumble into one of the areas that can result in waiver. And one of the key prongs, which we'll turn back to in a moment, is the in confidence prong, because typically if a communication is not made in confidence, the privilege is waived. And the joint defense agreement is in some ways an extension or a exception to that principle. But before turning to that, just quickly for general situational awareness, on the right-hand slide of the deck, I've noted the other key U.S. privilege, which is the attorney work product privilege, which protects materials that are made in preparation for and anticipation of litigation. Unlike the attorney-client privilege, the attorney work product privilege only attaches when there is the threat or a reasonable threat of litigation or some type of a contentious adversarial action. That said, materials produced that are subject to attorney work product don't necessarily have to be created or prepared by an attorney. They could be materials that are created by the business if that was done at the direction of an attorney, again, in anticipation of litigation. But really, I think the focus today primarily is on the left-hand side of the slide, which is the attorney-client privilege. Depending on who you ask, and frankly, depending on the court that you find yourself in the United States, sometimes the joint defense privilege is discussed or viewed as an extension of the attorney-client privilege. And sometimes it's viewed as an exception to ordinary waiver principles. But at the end of the day, that's really a semantic distinction. It's two sides of the same coin. And it's really pinged, as I indicated before, in that in-confidence prong, that second prong of the attorney-client test. Because typically, if you share communications with your coworker, between your attorney with your coworker, if you share it with your friend, if you share it outside of that attorney-client relationship, the privilege is waived. And that's a really important point in U.S. privilege law, because the waiver can be really, really significant and have really, really consequential implications for your case. Obviously, the precise and exact information that you've shared would be subject to waiver. But there are instances that U.S. courts will find that you've made a broader waiver and that you've created, for example, a subject matter waiver. So anything related to the communication that you've shared, even beyond what you've shared, could become fair game at a trial, which could have, of course, pretty important impact and consequences in the context of discussions that you've been having and thinking you've been having in confidence. What the joint defense privilege does, though, is extend this concept. It expands the universe of people that you are allowed to have these private, confidential, and privileged discussions with, beyond just your attorney-client relationship. But now it's allowing you to have this discussion with a wider group where you might have a common interest, a common legal defense. And this can be memorialized. It doesn't necessarily have to be memorialized, but it really opens the door for joint defense arrangements where you can now share attorney work product across defense teams, where you can share strategy across defense teams, and have a whole bunch of other benefits that that can be a byproduct of that. So at a high level, I think that probably covers what we need to say on U.S. privilege law. And why don't we turn to the next slide and jump a little bit more, head into joint defense privilege and joint defense agreements. So this slide's a little bit busy, but at the top, I've set out the concept of joint defense privilege. It's probably fair to say from the get-go that U.S. courts are a little bit all over the place in terms of the nomenclature that they use and the precise language that they use. I've used here the term joint defense privilege, which I think is probably one of the more precise ways to capture it. But you will hear courts referring to a joint defense doctrine. You will certainly hear reference to common interest and common interest privilege, which courts a lot of times use these terms interchangeably. I think there are distinctions if you're being really academic about it, and I will try to come back at the end. I have a slide or two around common interest, which to my mind, at least, common interest can capture a broader range of activity than just joint defense privilege. But in some sense, that's semantic, and if you're reading a U.S. court case and you see these terms, don't assume that the court's being as precise as we're going to try to be today, that they very well may not be. But in any event, if you have a joint defense arrangement, you enjoy this privilege, which we've just been discussing. From historical perspective, I included on the slide the oldest case that I could find, and not least of all, I included it because it's a Virginia case, which is where I grew up. So I wanted to do a shout out for Virginia, but obviously it's from 1871, which shows that this concept of joint defense privilege has been alive in U.S. jurisprudence for, I guess, nearing 150 years now. That Commonwealth of Virginia case is in the context of criminal law, and it was first articulated in the context of a common interest amongst co-defendants who are subject to criminal penalty, which is perhaps not a surprising way to see this concept first arise, but it has expanded in the intervening kind of 140, 150 years. And so today, joint defense privilege is recognized in all 50 states. It's recognized in federal law. It's no longer just like it was in this Virginia case in the context of criminal actions, but it applies in civil contexts as well. And that's been a creature of case law and evolution over, the better part of a century and a half. I would just flag that oftentimes in the United States, privilege questions are a creature of state law. And so you will have directionally the same rules of the road applying, but there are contours and differences that apply state by state. And there are some instances while federal courts oftentimes will look to state law for privilege. There are instances when there's a federal question, for example, where federal courts will look to federal common law as well. So one thing to really be conscious of in the joint defense context in the United States is what is the privilege law that is applying. But the bottom line is that typically, as long as you share a common interest and the communications, and this is important, and it's kind of drawn out in the cases at the bottom of the slide, as long as the disclosures are for the purposes of advancing a common legal interest, you find yourself within the contours of joint defense privilege. And like privilege always in the United States, there is a requirement that the communication is kept confidential. If it is not, that can again, if you're sharing materials outside of the joint defense arrangement, you could again have a waiver issue. So that's the privilege at a high level. And why don't we move to the next slide and dive into the joint defense agreement. So I've set it out at the top. A joint defense agreement, as I think I have flagged already, it can be oral or written, but as long as there is a common interest among the parties and the parties agree that there's an agreement, it doesn't have to be in writing, but there must be an agreement that they're going to work for their common defense and they are going to preserve the confidentiality of the communications, then you have a joint defense agreement. And as you might imagine, there are quite a few benefits from having a joint defense agreement or a joint defense arrangement. The key being that this now allows for coordination among the parties. It allows for information sharing, for work product to be shared amongst defense teams. It allows for a lot of efficiencies amongst the defense teams. Hopefully, it allows for there to be a consistency of defenses across the defense group. And so there are quite a few benefits that stem from it, whether it's oral or written. But that question is a key one at the beginning. Are you going to enter into a written agreement? Are you going to enter into an oral agreement? And it's not necessarily an easy decision. I must say that I have encountered practitioners that are across the range in their views on this. There are folks that never want to enter into a written joint defense agreement. Obviously, there are efficiencies there in terms of you simply establish that there's a joint defense arrangement and you move on. You don't have to go through the negotiation process for a joint defense agreement. Depending on your position, you perhaps preserve optionality in terms of what your agreement, the terms of your agreement may be. On the other side of the coin, I know practitioners that will always demand a written joint defense agreement, even in fairly simple cases. And some of the benefits are, of course, kind of the opposite side of the spectrum. You can have precise terms. You can specify the contours of the joint defense arrangement, the specific communications that are going to be covered, that are not going to be covered. You can define the rights of the parties. Are there going to be terms for withdrawal? Whether or not you have a joint defense agreement, it's kind of a legal question, and courts should not necessarily look to whether or not you have a joint defense agreement to determine whether or not you do. You can have a joint defense agreement and a court decides, for example, that you don't have a joint defense agreement. But having a written agreement can be helpful if it is later put to test by a court. showing that you engaged in communications and really genuinely believe you had a joint defense agreement and aren't kind of coming up with a after the fact explanation not to produce materials can be helpful. So those are some of the thoughts and the pluses and minuses that go into that question, but that is a key question at the start, and it can be a difficult one at the beginning of a representation when you're still trying to determine the facts, determine your strategy. With that, why don't we turn to the next slide? So obviously we've been, or I've been throwing around the term joint and throwing around the term common. The question exists is, what does that mean? The answer in the United States is, at least, is that it depends again on the court that you find yourself in. And as I kind of alluded to earlier, if you have a challenge in this space, if you have a challenge to whether there's a joint defense agreement amongst defendants, a court will look at the underlying facts quite closely. And the fact that you have a joint defense agreement may help, but it shouldn't be dispositive of the question. And so what a court is really going to look at is whether there is an underlying and common legal interest. Some courts and some states, the most stringent, are going to require an identical interest. An identical interest, you can imagine, even amongst co-defendants, is sometimes difficult to articulate because there are going to be differences between even very similarly situated defendants in terms of what their interests are in a litigation, what their interests are in a defense. But that's not necessarily all courts. There are plenty of courts that suggest that there only needs to be overlapping areas of interest, so not complete identical interest, but just an overlapping area of interest. And in some instances, you can have a joint defense arrangement or joint defense communications just on that issue where you have a commonality. But some courts will say if you have some overlapping interests, you can have communications on a whole host of issues, even issues that expand beyond that area of overlapping. So this is one of the instances where it's really important to understand the state that you're in, to understand the privilege law that applies there and the joint defense arrangements in that particular jurisdiction. And that might not always be an obvious question. You may be facing a regulatory investigation and have a real sense, as is oftentimes in the United States, that following any regulatory resolution, it's very likely that there are going to be the usual suspects on the plaintiff's side that are going to bring class action litigation. And you don't necessarily know where they're going to bring that litigation. They may bring it in New York, they may bring it in California, they may bring it in multiple states. And so sometimes at very early stages of a regulatory investigation, if you are entering into a joint defense agreement, you may need to think very hard about where the course of this litigation may lead, sometimes 5-10 years down the road, and what the contours are that a joint defense agreement might be evaluated under. So in terms of some practice points, I try to pull through a few. Well, actually, this case is worth flagging. I think it's an interesting case. This really shows the opposite side of the spectrum in Texas. Here, a court recognized that there was a common interest between co-defendants that had cross claims against each other. So that's really the opposite end of the spectrum from a court that's going to require an identical legal interest, which I think is an interesting example to point out. But as I started to do, pointing to some of the best practices, I think thinking really hard at the beginning about the privilege law that's going to apply, no matter what, if it's going to be an oral agreement or it's going to be a written agreement, think really hard at the beginning about what the common interest is. How can you articulate the common interest, state it, write it down, share it with the party that you're entering into a common interest agreement with, test it and stress test it. Because what you don't want to do, of course, is find yourself 3 years down the line being challenged in court and for the first time putting your heads together and saying, how exactly are we going to articulate our common interest? What exactly is it? Is it a legal interest as opposed to a business interest? Those are really discussions, no matter what form your agreement is going to take. If it's going to be a written agreement, I've entered into written agreements that are a page long. I've entered into written agreements that are 30 pages long. No matter what the size of it is, you really need to have that discussion at the front. What is the common interest? How would you articulate it? It sounds like a really easy point. It's not always obvious. And it's important to think through at the beginning. And there are instances where you can articulate a common interest across cases. You're not necessarily in the same action, but you're in different courts, perhaps in different jurisdictions. There are instances you can articulate a common interest that would withstand scrutiny in some U.S. courts, but you just need to think very, very deeply about what that common interest is and how you would articulate it. So with that, why don't we turn to the next slide? So somewhat similar to the discussion on the previous slide, the other kind of key question is there a legal interest? And this is somewhat similar to the concept which I may have talked about briefly in the attorney-client context. You know, attorney-client privilege only attaches in the U.S. when you're seeking legal advice. If you're talking to a lawyer about something that's commercial, about something that they're not using their legal qualifications for, the attorney-client privilege doesn't attach. That same principle here extends in the joint defense arrangement. So you need to be sure that there is a legal interest in the communications and a shared legal interest, and that the communications aren't just a shared business interest or a shared commercial interest. And again, somewhat unhelpfully, how you determine that changes and varies state by state. And so there are some states that impose a predominant interest test, which is the strictest. And so the predominant interest, the predominant point of the communication must be legal in nature. But there are many, many courts that have a lesser standard. And as long as some portion of the communication, some aspect of the communication was legal in nature, generally the privilege is going to attach to the entirety of the communication. So why don't we go to the next slide? And I would like to maybe just pivot a little bit. I think we've talked quite a bit, or at least I feel like I've talked quite a bit about the kind of broad contours of joint defense agreements. But I think it's important to kind of think through some of the issues that can cause concern. And so I put up this quote from the Eastern District of Pennsylvania, which I thought was right on point for our segue. And it reads, entering into a joint defense agreement is often indeed generally beneficial to its participants, but like skating on thin ice, dangers lurk below the surface. So a bit ominous, but let's go through a couple of what those dangers can be. Why don't we turn to the next slide? So this slide, and I think the next slide also kind of drills down to really the key risk, or at least one of the most prominent risks, which is what happens if there is a breakdown of the joint defense agreement. And in particular, if there's a breakdown of the joint defense agreement that happens down the line after you've shared confidential information in confidence. Now what is going to happen? And you can imagine this playing out in a variety of scenarios. Obviously, in a governmental investigation, oftentimes there is pressure and incentive for either under an amnesty program or something similar to be the first one in the door and to be the government cooperator and to receive leniency. So certainly in a joint defense agreement context amongst defendants in a governmental investigation, you're always suspicious and concerned that someone in your group may defect towards the government and try to broker an icebreaker deal and have all the benefits that flow from doing that. In the civil litigation context, it can happen as well. Oftentimes you'll see in complex civil litigation, whether it's antitrust, RICO claims or the like, early settlers oftentimes will have cooperation provisions as a condition of their settlement. And those are often touted in U.S. courts right alongside the monetary judgment when you have a class action, for example, to obtain approval of a settlement. So The risk here, and this is one of the things that speaks towards a written agreement, in my opinion, the risks here can be really mitigated when you have a well-drafted and memorialized written joint defense agreement that has specific parameters that spell out what happens in complicated and difficult situations such as this when you have an individual that's exiting a joint defense agreement. You know, what are the terms of that exit going to be? Are they going to need to provide notice that they're withdrawing from the group? Do they need to provide notice 5 days in advance of doing anything? Are they going to return the materials that were provided as pursuant to your cooperation agreement? On what timeline are they going to do that? Those are all key things that you would want to include in a written agreement and can help mitigate some of the risks that happen here. Strictly speaking, though, what you have said in confidence should not and cannot be shared by that party moving forward. If they have the information independently, if they have the information themselves, obviously sharing it in a joint defense scenario doesn't provide immunity to that information. But the materials that you provided, the information that you provided in confidence should survive them leaving the agreement. And if you have a written joint defense agreement, you can spell that out in quite a bit of detail. One risk that I flagged here, and I'll just talk about briefly, is in a joint defense agreement, there can be, and some courts have found, that a duty of loyalty arises between the attorney for one party and the client of another firm. And if that happens, and then that individual who you've now created a duty of loyalty with defects from the group, what does that mean for your defense of your client? What does that mean for the defense of your client if it becomes adversarial to the party that was once part of the group and now has defected? It can cause a lot of complications if there's a duty of loyalty. And so one of the things, again, that I would certainly recommend if you have a written joint defense agreement and if you're in a jurisdiction where a court may find that acting in a joint defense agreement creates a duty of loyalty, is that you explicitly disclaim that. You state as a specific term, there is no duty of loyalty. Nothing done in the context of this joint defense agreement is going to give rise to a duty of loyalty, and that can mitigate that risk. Why don't we turn to the next slide? And this is, frankly, more of the same, so maybe I can go through this slide a little bit more quickly. Kind of similar to the duty of loyalty is this concept of attorney disqualification. Again, this is in the context of having a co-defendant that defects from the agreement. There can be instances that would give rise to disqualification. I've cited the Roosevelt case, which you can read, which gives a little bit of context to one example. But if your attorney, for example, was going to have to cross-examine in a trial someone that was a co-defendant and use information that they provided in the context of that joint defense agreement to impeach them, to say, actually, what this individual is now telling the government actually isn't true, or there's reason to believe it's not true. And that's because it's the exact opposite of what this individual has been saying for the last 2 years in the context of our joint defense agreement. And that is a key area where the privilege can break when joint defense participants become adversarial to one another. The information that's shared in privilege can be used against one another. That's a key point I don't know that I flagged that you should be aware of. But if your attorney now needs to cross-examine someone that was once part of your group, if you don't have carefully drafted provisions that say that there's not going to be a duty of loyalty, that we're not going to allow for disqualification, you might have a situation where several years into a litigation, your attorney becomes disqualified. Even more potentially concerning, there might be disqualification that's imputed to the entirety of the law firm that you've been working with. And obviously, you don't want to find yourself, on the eve of trial and otherwise finding that you might need to find new counsel. So again, I flagged a couple of the best practices here that you can look to incorporate. Certainly, you would want a provision that says that joint defense isn't going to serve as a basis for disqualification. You would want an explicit statement that each party has its own attorney, has its own counsel. The joint defense arrangement is not going to give rise to new attorney-client relationships. A waiver of conflict of interest provisions of conflict of interest is a wise provision. And And as I discussed before, kind of notice provisions for exiting an agreement, a provision that says there's continuing confidentiality obligations, which there is anyways, but it's a good idea to have that written. Those are a few of the provisions that you could include as a best practice in that area. So why don't we move to the next slide? So on this slide and the next one, I've kind of just put together some hodgepodge, frankly, points and practice points. In the interest of time, I thought I would go through these rather quickly. And I think a number of these concepts on this slide, I think we've addressed just as we go. The joint defense agreement really is an extension of the attorney-client privilege. It doesn't create larger protections or new protections. There's no obligation just because you're in a joint defense agreement that you have to have joint positions and joint defenses on everything. Oftentimes you will see that there are divergent defenses that are developed. The example I was just talking about on the prior slide, if there's a dispute among co-defendants, the communications can become unprotected, which is a key risk to be alert to. This case, the Raytheon case, is a good one to note, and this is really down to a drafting point. In the U.S., as a matter of policy, you can only go so far with these joint defense agreements, and so having a notice provision and saying I need to give 5 days notice before I go talk to the AG's office about settlement, that generally will be fine with U.S. public policy. But having something stricter, trying to hold the group together no matter what, saying that a party isn't able on their own and independently to seek to settle a case, that generally goes too far. And courts will find that violates public policy, and they would not uphold at least that provision, and potentially it could jeopardize the larger agreement. And this final point is worth noting. Really comes up most often in criminal context, but courts in the U.S. Have pretty broad supervisory power over their docket, over the cases in front of them. It is not beyond the realm of possibility, although it is very rare, that they might want to see a joint defense agreement, that they might insist on particular terms. So I flagged that for awareness. And why don't we turn to the next slide on practical points. Just again, a bit of a hodgepodge here. It's always a good practice, a good idea to label communications as common interest or joint defense. And then in the interest of time, I won't go through all of these points, but I've listed out on this slide a couple of common joint defense agreement provisions that are helpful to keep in mind and bear in mind. So conscious of my time, let me try to quickly wrap up. Going to the next slide. This is a restatement of what we've just discussed, the joint defense privilege. I won't go through that, but it's generally that the top of the line is if you have a joint retainer. The bottom is really what we've been discussing primarily, a joint interest and how that protection works. And this is, of course, I think quite obviously in the contentious context, in the litigation context. If we go to the next slide, I wanted to draw out just quickly why, to my mind at least, common interest is a bit broader, even though it's often used interchangeably. Common interest, to my mind, does not have to implicate, at least in most jurisdictions, the litigation adversarial context. And so in this example, you will see it's privileged information being provided amongst parties and being provided because they share a common interest. The very last box on the left is the information is provided for litigation purpose. That really gets you closer to the litigation privilege. And there are some jurisdictions, New York is one of them, where they really have this requirement that the information for a common interest to arise, there must be an adversarial litigation context. But most jurisdictions do not require that. And I flagged that for this group and just understanding the practitioners that we have today. One of the contexts that might arise, and can turn to the next slide, is in antitrust merger reviews, where you do not yet have a contentious adversarial process. So you might not be in a joint defense scenario because you're not defending against anyone. In a lot of jurisdictions, you can have a common interest, all the same. And so you will find sometimes in the merger review context, when two companies are contemplating a transaction, that there is something akin to a common interest agreement or a joint defense agreement that's entered into before there's any challenge. And that's really in the context of the slide before that we were just talking about common interest. But there is, even if you find yourself in a jurisdiction like New York, where they require some adversary nature to the engagement, you can find some court cases in some states that will support the idea that actually a merger review, when you find yourself in a scenario that there's very likely to receive FTC or antitrust scrutiny, that there is already an adversarial common interest. There is already the prospect of litigation that gives rise to the necessary predicate for a joint defense agreement. That's a whirlwind tour. The final substantive slide, if we turn to, talks about some advanced issues. I'll just flag them in name. Judgment sharing agreements, you will find in the United States in some contexts, really in contexts where you have joint and several liability, whether it's a Sherman Act case or otherwise, and it's used to apportion liability amongst defendants at the start of the case. And it works to lessen what can be otherwise harsh implications of joint and several liability. They are complicated, probably much more complicated than joint defense agreements, and probably I could spend a full hour or more discussing them. Temporary takeout agreements are a mechanism sometimes used in the United States to get towards judgment sharing agreements. But I will leave it at that. I am conscious I have gone a little bit over my time, and I don't want to step on Alan's toes. So I'll stop there. If there's any questions, I'm certainly happy to take them. But otherwise, I'll turn over to Alan for the European piece.
Perfect. Thank you very much, Patrick. And I'm not sure if you can see me on the screen, but no problem. So good morning, everybody. It's still morning. Thank you very much. So my name is Alan Ryan. I'm a partner at Freshfields. Brussels is basically my home office, but I'm currently now working in California. I am an Irish and an English lawyer, and I'm delighted that some of my cases have actually been before CAGI, or used as precedents, and we're very much looking forward to that to continue. So one of the ones, for example, was UPS, the merger appeal, where we successfully appealed the prohibition of the UPS TNT transaction. And that's been considered by CAGI, and we're very much looking forward for that cooperation to continue. So first thing I need to say is obrigado por me permitir falar inglês. Sei o inglês melhor que o meu português. So with that, thank you. It's much safer legally to do that. The first thing I'd say is that JDAs are not a European concept. They are used in Europe, but they're not in themselves an agreement as such. It's not grounded clearly in the law. And to understand their use, it's actually worth looking at the differences in the basic concepts of privilege in the various European countries, because that's what underlies the whole approach to cooperation amongst lawyers as well as these agreements. And it is very, very different. So on the one hand, you have the common law jurisdictions on the European continent. There are 6 of them. They used to all be in the EU. 3 of them are now no longer in the EU. So those are the UK jurisdictions. So that is obviously England and Wales. So there's no concept of the UK as a jurisdiction. There's England and Wales, Scotland, and Northern Ireland. They're no longer in the EU. They used to be. And then you have the 3 that are still in the EU, which are Ireland, Cyprus, and Malta. So there are still 3 common law jurisdictions in the EU. That means there are 3 sets of judges in the European courts who still come from common law backgrounds. Now, I'm just going to take an aside. We're looking at the World Cup coming up soon, and to say that the name of the jurisdiction is Ireland. But for those of you who know it as the Republic of Ireland, that is only a football team, right? That is only a football team. There are 2 football associations on the island of Ireland. the Football Association of Ireland, the Irish Football Association, and FIFA decided that the Football Association of Ireland plays under the name the Republic of Ireland, and the Irish Football Association plays under the name of Northern Ireland, but it's only a football team. It's not a legal jurisdiction. So bear that in mind. So the team that Brazil beat 3-0 in the World Cup in 1986, that's Northern Ireland, which is a legal jurisdiction. The team that you played in 1987, I won't mention the result, that's playing as the Republic of Ireland, but if any member of the team ended up in court there, they would be in court in Ireland. So that's our general knowledge for the day. In all those common law jurisdictions, though, the basic principle of privilege is the same. It's functionally almost identical to what you have in the USA. The terminology is different, but basically you have two privileges. One is legal advice privilege, which covers seeking legal advice from a lawyer, and any materials prepared for seeking the advice, the lawyer's advice, and any materials then attached to the lawyer's advice, that is covered by legal advice privilege, very similar to the USA. You then separately have litigation privilege, which is any materials prepared in contemplation of litigation. You would think it's functionally the same. It's actually wider, which is that communications with third parties are much more likely to be covered under the litigation privilege than they are under the legal advice privilege. So, for example, if you seek to instruct an economist, for example, before there's any litigation, if the lawyer does it, that's one thing. But if the client does it, then that is unlikely to be covered by legal advice privilege. Whereas if they were to do it in contemplation of litigation, then it would be covered. So bear that in mind. That's most important in the context of internal investigations, because notes of internal investigations, if there's no really contemplated litigation, may well not be privileged. You need to be particularly careful about that. And I suspect that that's probably the big difference with the USA, but I think this will be important, obviously, in matters in Brazil. If you've got, for example, a cartel investigation or cartel defense, internal notes of conversations with employees may well be considered a turning work product in the USA. They may well not be considered privileged under legal advice privilege in the European common law jurisdictions, if they're relevant, obviously. Now, why is that relevant to JDAs? Well, all of those 6 jurisdictions have a concept of what's called common interest privilege, which is functionally very, very similar to the joint defense privilege in the USA. And as its name suggests, material shared amongst parties who have a common interest in legal advice or in contemplation of litigation or in legal proceedings are protected. The key is that those documents must be already privileged. So a particular company's discussions with its lawyers, materials prepared for its lawyers, those are, as long as those are already privileged, then they may be shared under the common interest privilege without losing that privilege. The key is that you have a sufficiently close interest in the legal advice or in the outcome of the legal proceedings. So it would cover, for example, cartel defendants who would all be regarded as having a similar interest in the outcome in defending the cartel, particularly on substantive grounds, even though each alleged member of the cartel may seek to settle or apply for leniency or immunity or something like that, they would typically have a sufficiently common interest. The same thing goes for legal advice then for a contemplated merger, where there may well be no legal court proceedings, but there would be a common interest in the legal advice there. Typically, it's untested, but it's used commonly, and I don't think anybody seriously expects that would be challenged. Now, importantly, you do not need a written agreement to benefit from the common interest privilege. The mere fact of having the common interest gets you there. And in fact, the written agreement, you do see written agreements, but much less commonly than in the USA. A large number of companies and people are just content to rely on the common interest, and any sharing of documents. You don't even need to stamp them common interest, but many people do that. That's enough, because a written agreement doesn't get you any additional protection over and above what the common interest privilege does. If a party wishes to abandon its common interest and go and seek to settle, for example, then the materials provided to them in confidence previously cannot be used for the purpose of seeking leniency or immunity, something like that. Indeed, probably if you try to do that, the lawyers themselves who used it would be subject to disciplinary sanctions if that were to happen. So the primary case in which people use joint defense agreement is when there's an international aspect to this, and you are therefore looking at several jurisdictions, and you just need to make it clear what you can and cannot can and cannot do under those circumstances. So, but functionally very similar to the USA. The main exception is that the prevalence of written agreements is much lower on that. So that's the common law jurisdictions. Similar to the USA, probably not very different. Much closer, I think, substantively to Brazil are the civil law jurisdictions in Europe, and there you have a big difference with things. So you have a number of civil law jurisdictions, all obviously continental Europe. All the common law jurisdictions happen to be islands. It's just a geographical quirk. On the continent, you have the civil law jurisdictions. You have some like Belgium and Netherlands, which do have privilege. It looks rather different than the common law privilege. It, in practice, turns out to be very similar. But the primary difference is that there the privilege is not the company's privilege. It's the lawyer's privilege. So under the common law jurisdictions, that privilege belongs to the client, and it's the client who can assert the privilege, and it's the client who can decide to waive the privilege. In the civil law jurisdictions, it's not the client's privilege, it's the lawyer's privilege. It's actually much more closer to the attorney work product. It's really merging it all, merging both legal advice and attorney work product under one heading, and then putting it all as attorney work product. That is the lawyer's privilege. So the privilege attaches to obviously the lawyer's advice, and then materials that are in the lawyer's possession or were prepared by the company to give to the lawyer for legal advice or for litigation. Typically, it will also cover materials provided to third parties by the lawyer, because although it's not very clear in the law, that is regarded as the lawyer's function. It is the lawyer's function, for example, to seek expert evidence, such as from an economist, and therefore the lawyer will go and do that. And therefore, that's typically what you do. And typically, it would be the case that actually that advice was kept only by lawyers in the legal advice. It's actually quite difficult in most of these countries to search a lawyer's office. For example, in Brussels, if you're under the supervision of the Brussels Bar, the authorities can't search a member of the Brussels Bar's records, except after giving prior notice to the head of the bar, who then gets to send somebody to supervise that. There is, I should also say that in several of these countries, the privilege also attaches to in-house lawyers. So common law jurisdictions, as long as the in-house lawyer is a qualified solicitor or barrister, then that's fine. The privilege attaches to anybody who is essentially a member of the bar. In some of the civil law jurisdictions, in-house lawyers are members of the bar. In others, they are members of essentially a different bar. So in Belgium, for example, they would be members of the Association of Company Lawyers, of in-house, which means lawyers employed by companies. And the reason being that the bar rules provide that a lawyer must be independent. So if the lawyer is not independent, then the bar rules don't apply, but you have separate rules that apply then for the members of this institute. It's functionally the same. In other countries, there is no privilege for in-house lawyers, even if they are members of an in-house, legal institute, for example, which it causes a lot of problems at EU levels. I'll get onto in a minute. Now, in these countries, there is no concept of joint defense or common interest privilege legally, but in practice, if a lawyer consults with co-counsel for a legal advice or for litigation investigation, then that's typically regarded as within the scope of the lawyer's responsibilities, and therefore it's covered. It's not a separate privilege. It's basically covered. Again, anything that you would do as part of your defense or your representation of the client is basically covered, and important. It's your privilege to waive or not. No written agreement is needed. It just needs to be within the normal scope of the lawyer's activities. There you do see joint defense agreements or written agreements are, I think, even rarer than in the common law jurisdictions, but they typically apply when you have several jurisdictions in play here. And I get onto that in a minute in the case of damages recovery actions. And there are differences in the scope of the privilege across the countries involved. So that's those civil law jurisdictions. I suspect they may well be closer to Brazil. You also have in Europe a number of civil law jurisdictions where there is no privilege at all. It's actually very simple. It just doesn't exist. That's Germany. Germany is the classic example that there's no privilege. So there's nothing to be protected. Joint defense agreement won't help you. It's not protected. Now, in practice in Germany, if you have a investigation by administrative authorities, which do work internationally, like the German Competition Authority, the Bundeskartellamt, they are mindful of the privilege in other jurisdictions. So often they exercise self-restraint. They often ask formally for certain documents, but then they will agree not to enforce that because they know that these materials would be privileged in other countries involved in the same case. So it's commendable self-restraint, but they don't have to. And importantly, if it ends up before the courts, then that might not happen. Now, the important thing, though, is that other than the legal advice itself, often what you look to protect in joint defense agreements is the underlying materials. It's actually much less relevant because the extent of discovery or information gathering in these countries is typically much less than in the common law jurisdictions. So of all the countries, essentially how important is it to protect these things? Civil law countries are much less document intensive, and they don't have the same discovery as you have in the common law countries. Therefore, privilege is much less important. It's typically the legal advice itself that's important, and that is much easier to protect, except in countries like Germany. On the other hand, the common law jurisdiction, particularly Ireland, there can be very extensive discovery, and therefore it's much more important to protect the underlying materials. Now, where you get into difficulties, and this is the interesting thing, and maybe the EU itself is a microcosm of international cooperation, is what do you do when you have multiple cross-border cases? So you've two, which is you have EU level privilege as well, which is that the case, it may be an Irish case or it may be a German case, but it's actually being investigated by the European Commission. or the case may be in Ireland or in Germany, but the law at issue is EU law. So what do you do there? Well, that's rather unfortunate outcome, but the question of privilege was considered by the European Court in the famous or infamous AXO case. And there essentially, it's quite a complex ruling, but what the court said was, since there is not an identical form of privilege in all countries, particularly as regards in-house lawyers, for in-house lawyers, since some countries don't protect that privilege, then there is no privilege. No in-house lawyer in Europe, across the EU, has protection privilege, even if in their own country they are privileged. So you have a case, say, in Ireland or in Belgium, where the in-house lawyer, if it's a domestic case, either in litigation, domestic courts, or domestic competition authority, the in-house lawyer's correspondence is privileged. But if all of a sudden the European Commission takes over jurisdiction over the case, that privilege is lost. It's unfortunate, it's almost, you could say it's the lowest common denominator approach to it, but that's how it is. On the other hand, there are situations like in Germany, where if it's a German domestic investigation or German litigation, there's no privilege, but the European Commission takes it over, then there is. So it causes some issues. In practice, that is only relevant in competition cases, either merger cases at the European Commission level, which is actually the big ones, or cartel investigation, the basic investigation to establish liability, if that's done by the Commission. And for that, again, there is no EU law on joint defense or common interest privilege. But in practice, you see that the practice in, say, Ireland and Belgium, very different law, is functionally the same, and therefore nobody questions the exercise of joint defense. If you are two merging parties, you obviously have the same interest in the outcome of the merger. You can share information and advice across the parties. That's regarded as normal, what a lawyer would normally do in Belgium. It's a common interest. It's not written down in detail, but that's it. There is no need for a written agreement. You more or less adopt the general principles of most of the European countries, which do give privilege in that situation, and on that. So that is relatively simple. Joint defense agreements do exist, but that's typically because there is a transatlantic angle to it. The more common case now, or increasingly common case, is cartel damages cases. So this is just the damage. Liability is already established by a European Commission decision. Now you have the damages cases. These are done in national courts under EU law, under the damages directive, but it's national courts. So it's the national courts, the national procedural rules apply, and therefore the national privilege. And this is where you get a variation. The European Commission has a practice now of allowing common interest privilege without a agreement, and has never really pushed the limit on it. That's not an issue. The bigger issue is in these follow-on damages cases, where you have cases in Germany and you have cases in other places, and that is where you would enter into a written agreement. And that is to provide that in those countries where there is no privilege and you're in court there, to basically provide that any materials provided to be seen by lawyers in jurisdictions where there's no privilege must only be used, it cannot be used for the purposes of the German proceedings. They can see it so that they can see what's going on elsewhere, but that is purely for the purposes of seeing the conduct of the case in other countries. It is not to be used in Germany, and that's a way of basically saying, they didn't have this as part of their regular exercise. They only saw materials that are being used in the other countries, which are privileged in those other countries. They're actually not relevant to the German case, and therefore that's how you do it. They are typically drafted in a very careful way. There's no one size fits all for it, because you really have to tailor it to the specific countries at issue. The damages cases, the big place is the Netherlands, where there is privilege, Germany, where there isn't, and Spain, which is closer to the Netherlands. Plus, typically, you'll also have one of the common law jurisdictions. You still have cases in England for EU law, and you'll have a parallel case in England for violation of UK competition law as well. Those are important because of the higher level of discovery that you can get in those countries. And so therefore they also require very, very careful cooperation. The other reason they require careful cooperation is obviously post-Brexit, UK is not in, so the AXO judgment doesn't apply. Can't really apply the general principles there. So very much case by case. There is no template. This is a new area of the law and people are working through it. So with that, I'm just looking at the time. I think I'll stop there and turn it back to the organizers. It looks like we may have some questions. So again, thank you very much for your attention. Delighted to answer any questions you may have.
Thank you very much. Well, it's so much information and all very interesting. And it's also good to know that you could both speak for even much more time here. We would really appreciate it. But this is our initial conversation here at the IBRAC on this topic. And I think you brought very useful tools and information so that we can start this discussion. So with these presentations, I would like to ask everyone in the audience to post here a Q&A, your questions, or also you can ask them here in the phone. I think you just have to unmute. While you are thinking, Carol, why don't you start with a couple of questions so that we can move with the discussions?
Sure. Well, Ellen and Patrick, thank you very much. It was really very enlightening. It was very interesting to hear from both jurisdictions. And of course, as Alan said, here in Brazil, we don't have that extensive discovery phase as you have in the US. So the privilege discussion still is not that important as in the US, but we will certainly start facing this type of discussion. And I was wondering, I know the main purpose of the JDA is to ensure that the information remains privileged so that the attorneys don't waive on that privilege. But, and I know we didn't have much time to discuss about the other specific clauses, but maybe Ellen and Patrick, you can talk a little bit about other common clauses that are inserted in JDAs. So I know, for example, that you can establish to share costs of experts by means of a JDA, or you can establish the obligation to share information with the other attorneys. So maybe if you could talk a little bit about this topic, I think it would also be very interesting. And I think we will need another round of discussion because I know we have a lot to talk about.
Yeah, no, thanks, Carolina, and I'm happy to tackle that one first. And Alan, please jump in. This, I agree. I mean, this could be a discussion unto itself, and I think I flagged, in the United States, the joint defense agreements can vary from, a one-sentence email from an attorney saying, I'm providing you these materials pursuant to a joint defense interest, to a heavily negotiated 30-page document. When you get towards the other end of the spectrum and you're talking about a 30-page document, there can be all kinds of bells and whistles attached. I do think one that I flagged, or I think I may have flagged during the discussion, is important, which is the terms of withdrawal. Is there going to be notice before you withdraw? Is there going to be a return of materials on what type of a time frame? Those are features. But as you flagged, Carolina, there can be much more, which goes beyond kind of the core issue of establishing a joint defense arrangement and goes more towards practicalities. So it can go to things like cost sharing. How are we going to retain experts? How are we going to pay for experts? And that can be a complicated discussion all into its own. If you're talking about a complicated cartel case or antitrust case, how do you divide costs? Is it done on a per capita basis? Quite a few times joint defense agreements will provide for per capita splitting, but does that make sense when you have defendants where one defendant has 40% market share and another defendant has 5% market share? How do you apportion costs? And depending on your client, you can imagine that you might argue different sides of that at different instances. So major antitrust cases in the U.S. Are subject to joint and several liability and treble damages. So certainly a key argument that can be raised is that costs for experts and the like should be shared per capita, because you're not just on the hook for your damages, you're on the hook for everyone's damages. And typically, if that happens, the allocation of work might vary. I mean, certainly, you would expect the firm that is representing the company with 40% market share to be carrying the laboring oar in some context, maybe driving forward the main motions, defending or taking the depositions of key plaintiffs. But that type of work allocation can be spelled out in joint defense agreements. I guess I would caution that it's a complicated discussion, and sometimes the case can be moving ahead without you. And if you wait for a perfect allocation of costs and those types of issues, you might let the perfect be the enemy of the good. But there are quite a few features. I think one of my slides tried to list out some of them, but I'm sure there's some others that are worth thinking about. And maybe I'll stop there, and if Alan has anything to add.
Sure. Absolutely. I think there's a couple of things that you can do which are very much in everybody's client's interest that a joint defense agreement can be useful for. So, for example, if you are defending a cartel, or indeed even in a merger situation, you could have several sets of economists or other experts on the case. Each party may have it. Well, it may be typically would be very helpful for that economist to have access not only to their own client's data, but to all the other parties' data on it. So you would want to provide in that the economist will do this, and that this is part of essentially a joint defense process, and the data that's provided from party A to party B's economist should still be covered. In some countries, it's untested, but I think so far I'm not aware of any authority or any court ever objecting to that. So that's the type of thing that you would do, and of course, no company is going to give up its own data to some third party who's not in a professional relationship with it, right? It's fine to give it to your own lawyer, or because you've got a lawyer-client relationship with it, right? If you go and you misuse that data, you get disbarred. Or you give it to your economist, you have a contractual degree of protection. You don't have that with the other party. So that's the type of thing that you would put in a joint defense agreement. The other thing that you could have is, for example, in a cartel case, or even in a JV or an alliance, it may well be that you actually have to look at the law or the factual situation in different countries or different areas. And you may say, well, the country, the company from that country will take the lead on the defense on that particular area. In airline alliances, it's quite common, for example, that the home carrier, so if you had an alliance across the South Atlantic, for example, that the Brazilian carrier or LATAM would take the lead in relation to the Brazilian market and dealings with CAGI, and the other one would take the lead in dealings with its own authority, its home authority, essentially. So all that can be decided in joint defense agreement. Sometimes it's also just agreed in the main merger agreement, for example, between the parties. Which also can cover the costs, or in the JV agreement. It doesn't really matter which. Yeah, but I think that it's very important to think, if you will, offensively, and say, right, Now that I've got several other parties in this case with me, what can I do to help my own client's defense? Right? In terms of how can I use these other people to do a better defense than I could do on my own?
Mhm.
Yes. I was thinking in terms of jurisdictions and the explanations you made, what would apply the best to Brazil? And based on your examples, Alan, I think it could be, so let's take the example of Germany, right? Even though there is no privilege there, I would assume that defendants in a cartel case, for instance, could be interested in exchanging confidential information among them, but with this purpose of working on their defenses, right? So that they can help each other and so on. So in this case, would it be still advisable to have a joint defense agreement, or would that be possible through another type of agreement? Or
It would definitely be, yes, because you need to protect the confidentiality of it. So as Patrick said, you need to protect that the other side will use that and go and use it to go and apply for leniency, basically, with your materials. The joint defense agreement does help you, and you've nothing to lose. So even in Germany, for example, where there is no privilege, you're still better off cooperating with the other defendants in a cartel case, for example, because your own materials are not protected. Their materials are not protected. So the fact that you exchange them doesn't change anything. So unless the only time that you might not do that is if there's a party who's not yet in the investigation. They're thinking, right, I'm not going to be brought in this investigation. In that case, maybe you stay out of this. So you stay under the radar screen. They don't have your documents, anything like that. There, the danger is you give another party your documents or your information. They're in the investigation. They get asked, and then the authorities says, I see not only company A is in this, but company B is worried too. Right, now I'm going to bring company B in. So that you don't want to do. But if you're all already in the investigation, you're already all subject to information requests, for example, you've nothing to lose and you've potentially everything to gain. The key point is, right, we all know what it's like. There's leniency is a race. You go to these oral hearings at the European Commission and you've a lot of companies that go, yeah, I agree, I'm guilty, but I gave more information than the other guy. I should be higher up the ladder than the other person, right? What they told you is not enough. So you know, it's not a solidarity. There's not much solidarity in these cases. Then you need to make sure that your information is not used for the other person's leniency application. Yeah.
Yeah, and in particular for a multi-J investigation, right? Because they could get information in one jurisdiction and then run to the other one. Yeah.
Correct. Now, the other point is, it's very important, is you, of course, your real difficulty is if you've a situation, you have a country like Germany, for example, that's involved in investigation, which typically anything that would involve Brazil is more likely to be a major global deal. It's more likely to be the European Commission, but not necessarily. So European Commission there, you do have privilege, so you're okay. If it's a German case, on the other hand, then, as you say, multi-J, then even if the Germans, so you have two things. The German authorities say, give me your information. That includes all the information that, you know, the legal advice. You can refuse to give Brazilian legal advice, for example. If it's protected in Brazil, you can say, sorry, I'm not giving that to you. That relates to Brazil and it's privileged in Brazil. And it's of no concern to you whatsoever what the Brazilian law on the matter is, but you shouldn't undermine Brazilian privilege. It's untested, and I dare you to take this to court. One, but two, importantly, even if they get it by mistake, unless you agree to a waiver, for them to discuss with the Brazilian or other authorities, then they still can't use it. They can use it in Germany and it can be in their final decision, but they can't share it with other authorities. So the real trick is you can protect yourself if they want to share it with other authorities, they normally have to come to you to seek a waiver for them to exchange information. And then you can agree in the waiver that they cannot share any materials that are privileged. So there are ways of protecting yourself, but you're quite right that it's in that typical multi-J situation where you would definitely want to protect yourself as much as possible vis-a-vis the other parties. The classic one being, if they get an economist on board, you've got your economists. If they can see the discussion with the economists, then they can use it to undermine, you know what it's like, the economist paper. Then they can write in their own decision. If their decision comes first, yeah, we looked at it and we found the following flaws, which may or may not be credible. And then Kaji then sees that decision and says, well, you know, we saw that the Bundeskartellamt didn't appreciate found the following flaws, so we'll go along with that too. So that's what you need. That especially needs to be protected against.
Thank you.
And I guess I would just add, in some ways, you know, that's similar to when you have a single client that's multi-jurisdictional as well. You know, you might have the KJ investigating, you might have the European Commission investigating, the Financial Conduct Authority in the UK and the Hong Kong Monetary Authority, and you're trying to set up your team and the flow of information. And just as you would in that investigation, have really deep thought at the beginning, what information are we going to bring into the United States? If there are materials that only reside in Brazil, maybe we will never bring those into the United States because we want to articulate to the antitrust division of the Department of Justice that those materials really are outside of the scope. And so those same questions that you're thinking about in a single client multi-jurisdictional case really animate a lot of the thought process, not all, but a lot of the similar themes that you're thinking about in a joint defense agreement, in particular, as Anna mentioned, a multi-jurisdictional one.
And Patrick, I have another question for you. I think something that will be very interesting here in Brazil in the context of damage claims deriving from cartel will be the judgment sharing agreement, by which you establish and allocate liabilities due to joint liability. And I'm wondering in practical life, how do you make this allocation? And is it somehow enforceable towards third parties? I would just like to better understand, because I think it will be very interesting to start this discussion here in Brazil too.
Yeah. I guess in a word, it's complicated.
I can imagine.
Yeah.
That's why I asked.
Yeah. Negotiating joint defense agreements and judgment sharing agreements specifically take a lot of time, a lot of negotiation. You need to think about, first of all, an early question from a U.S. Standpoint that often arises is conflict of interest. A lot of the firms will have as clients other people in joint defense groups. A lot of times, negotiations for judgment sharing is a task that has to go in-house. External counsel, a lot of times, the ultimate features and certainly the key issue of allocation. A lot of times, that's a discussion that moves in-house. But how you arrive at a number is part art and part science. Obviously, things like market share are critically important. But then, of course, and we've been talking a lot about cartel cases and follow-on actions from antitrust authorities. People are looking at, how do you get an indicia of relative culpability? Some parties might have an adverse finding from the European Commission. Some parties might have a finding from a prudential regulator for a much different quantum, for a much different amount. So how do you kind of assess liability amongst the parties, and how does that play into it? Obviously, there's the risk in the U.S. of joint and several liability. How do you weigh that risk? And so it's a complicated negotiation amongst a number of oftentimes very, very sophisticated parties, and a lot of issues can arise. You can find scenarios where even if there is very small market share, participants say, look, there needs to be a threshold skin in the game amount that people are contributing. So it's a difficult discussion. In terms of your question about enforceability, they are not, there's not a huge amount of case law in the US with these types of agreements being challenged. I will say you find similar agreements on the plaintiff side when you see plaintiffs brought together, for example, in a complicated opt-out action in the United States. There are plaintiff agreements that are holding the group together, apportioning how recovery is going to be obtained. But they haven't been tested a huge amount. The enforceability, there is typically a recoverability element from the other parties. There is typically a way that you can become a discharge signatory to such an agreement. So if you obtain in language in your ultimate settlement agreement, if you decide to settle apart from the group, if you obtain language that carves your commerce out from the case that the plaintiffs can otherwise recover against. So just to take an example, a simple example, party A, B, and C, and let's say each one has 33% of the market. Party A, they're all in a joint defense agreement, and now party A goes off and settles with the plaintiffs. If as part of their settlement, they obtain a provision that says no longer can the plaintiff obtain damages from the two that remain that relate to the first party's 33%, that would typically allow you to be a discharge signatory under a judgment sharing agreement. But it's a complicated agreement. It is a potentially very beneficial one, but it requires a lot of time and thought and probably a whole another session.
Yeah, but it could avoid contribution claims in the future. I know it must be hard to negotiate, but it can also avoid extensive litigation afterwards. Yeah,
no, absolutely. And this is probably a point, and maybe this is what Alan is going to talk about. There is in antitrust law in the United States no right of contribution, which is very, very different, for example, from the United Kingdom, where there is a right of contribution against co-defendants. And that obviously animates different thinking around these types of agreements.
Yeah, absolutely. I was going to say exactly that, which is that it's quite common in cartel cases, damages cases, that you will sue one party, and then they are the ones then who has to bring everybody else in to share the contribution. So that's one area where this is important, because the other parties will go, no, I'm not actually signing up any defense agreement. I'm going to leave you do it, and if you sue me, I'm going to defend there. So it can actually be pretty adversarial. The other area that you've got is, and again, this varies across countries, is an individual company that's found guilty of, say, competition infringement. If it was owned by different shareholders at different points in time, then those shareholders can be, liable for part of it. So it depends on the jurisdiction, but typically you will have a fine on the company, and then you have a separate fine on the shareholders. You could also, though, have a situation where you just have the fine on the company and its shareholders in one, and they are jointly and severally liable for it. Typically, that comes in the actual fining decision, right? Each jurisdiction will decide that differently. But you can have a situation where, say, you had three owners over a point in time. They all have a solid agreement, solid interest in defending on the substance. Nothing happened, but they're no interest whatsoever when it comes to sharing the quantum, and that needs to be decided. Typical way it's done is if you are buying a company that is in an investigation, then you will actually provide in the share purchase agreement what the liability is, and importantly, who will lead the defense as well. And that's actually an agreement amongst the companies. If the case is known, then that's fine. Problem is, if the case isn't known at that point, but that there's a vulnerability, what do you do to avoid drawing attention to that? That isn't so obvious. And in many cases, the simple solution is to walk away and simply not buy the company, unfortunately. But otherwise, you then need to, depending on the country, you need to think about if you really want it, but you don't want the liability, then you need to deal with it. You can do it. You can add in the likely amount of any sanctions into the purchase price and things like that. So it's possible, but it needs to be thought of very much on a fact-specific, country-specific basis.
Well, we have 2 more minutes, and the one question here from Daniel Rocha. I'll read it to you. In the US or in the EU, can an investigated party negotiating settlements deny access to legal advice documents, such as legal opinions? Would that be a fault to the settling party's duty to cooperate?
Yeah, so from the US perspective, it's interesting. DOJ had a policy, I'm going to say 6 or 7 years ago, pre the Trump administration, which attempted to articulate that providing access to privileged materials was a factor in assessing cooperation. That was pushed back against extremely hard by the whole US bar. It's somewhat anathema to the key privilege that we were discussing today, the attorney-client privilege. And the DOJ has thankfully walked back against that. Every administration and the Biden administration just recently made a pretty major statement on cooperation, what they expect for cooperation, pointing to individual liability, the fullness, the frankness, the speed with which cooperation is given. But thankfully in the US, at least as a matter of policy of the DOJ right now, waiving privilege is not a factor that's used in assessing your overall cooperation.
Yeah, and it's the same in the EU, right? The access to legal advice is almost a fundamental right. So no government authority can insist that you give it up in order to cooperate. That's not an issue. The one area you do need to be careful, though, is if you are cooperating, you don't have to provide privileged information. Frankly, in any case, you shouldn't. But at the same time, you don't want to hide behind privilege. You don't want to be too aggressive in your use of privilege, because if you withhold a document that you claim is privileged, that then comes out and then there's a question over, and it's clear that really you should have given it, it's not privileged, then your degree of cooperation will be basically almost voided at that point. So you need to, at that point when you don't need to give privileged information, but you do need to play it very straight with the authorities.
And this is a place where I would, cross-border issues become tricky quick. Under English law, there's a concept of selective waiver that is much more robust than in the United States. So I have frequently been in discussions where we're before a UK regulator and we want to make selective waiver around an issue that is key to the investigation, but you need to think long and hard about the implications and what they might be in the United States, where selective waiver, generally speaking, isn't recognized, and a waiver in the UK may mean that you're opening up those materials to discovery to US regulators and potentially down the line to civil plaintiffs. So it's a complicated cross-border issue.
Interesting. I'm afraid we have to close. Before that, would you like to make any final keynotes to us on aspects that you think could be useful for us in Brazil?
Well, it's a lot of pressure. I'll go first and let Alan gather his thoughts, and he can summarily close for us with a European accent in a way that's dignified. First, just thank you all very much for inviting us to attend. I've really enjoyed it and hope some of it has been useful for you. I think that the key question that I would impart is that you really need to think long and hard at the outset about what the common interest is, how you would articulate the common interest, and commit it to writing, even if you don't have a written agreement. It sounds simple, but that is the heart of the issue in the United States. That's the heart of what a challenge will be focused on, and you can't spend too much time and energy at the outset thinking about that. So that would be my parting word, and I will hand over to Alan.
And I would say exactly the same thing. As I would say, the only difference is over here that written agreements are less common, but you need to think very carefully about whether you need it. If there's differences in jurisdictions, it's multi-jurisdictional, etc. So plan on having a written agreement. unless you conclude that it's absolutely not necessary. The default should be have it and take it from there. And otherwise, I just thank you very much for your attention. I wish you good luck in the World Cup.
I wish you too. God save us from the Germans. Thank you all very much on behalf of the Competition Committee and the Litigation and Arbitration Committee. This discussion was really enlightening, I think, for all of us. It's a pity we don't have more time to go on, but I'm sure we can start thinking of other events, right, José Inacio?
Yeah, definitely. I think again, Alan and Patrick, it's an interesting matter, and we'll definitely have more opportunities to get this discussion going and get deeper on the other topics and other questions that will definitely arise. So thank you, everybody. It was a really, really good discussion, and it's really appreciated. Again, Alan and Patrick, that you took your time to be with us today.
Yeah, pleasure.
Thank you all.
Thank you.
Thank you very much.